You do not want $1 million injury case because to have $1 million injury case, you have to sustain significant injuries and endure significant pain and suffering. And honestly, my health is too important, and I assume you feel the same way, that your health is more important to you than the money. To make matters even worse, even if you are someone that has sustained severe injuries in an accident, it does not mean you automatically have $1 million injury case. In this video, I will go over the key factors in determining whether or not you have a case that is worth at least 7 figures. The first key factor I will discuss is liability. To have $1 million case, you must prove at least some liability against another party. To do this, you need to be familiar with your state's liability laws. In my state, Kentucky, for example, in car accident cases, typically you must show another driver or party was at least partially negligent in order to make a financial recovery. In dog bite cases in my state, however, dog owners are typically found to be strictly liable for the dog bite victims' injuries and damages. Strict liability is an easier standard to prove and typically means that the mere fact it happened, the party, for example a dog owner in my state, is automatically liable. To know if you have $1 million case, it's a good idea to be familiar with the negligence laws in your state. There are 3 different categories of negligence laws in the United States. The first category I will discuss is contributory negligence. As of the date of this video, only 4 states have contributory negligence laws in place. Those states are Alabama, Maryland, North Carolina, and Virginia. However, Washington, D.C. also has contributory negligence laws in place. Under a contributory negligence system, the injured party is completely barred from recovering any damages if they are found to be even slightly at fault for the accident, typically even if only 1% at fault. This is the harshest system to injury victims in the United States. The second category of negligence laws in the United States are pure comparative negligence laws. These laws are the most generous to injury victims and are adopted by 12 states at the time of this video. Under pure comparative negligence laws, an injured person is allowed to seek compensation regardless of their level of fault in the accident, so long as they can show at least one other party is at least 1% at fault for the accident. The amount recoverable, however, is reduced based on the injury victim's degree of fault. The state I practice in, Kentucky, is a pure comparative negligence law state. Under a pure comparative negligence system, for example, if you're 30% at fault, you receive 70% of the damages from the other party or parties found to be the remaining 70% at fault. The last category of negligence laws in the United States that I will cover is modified comparative negligence laws. Under these laws, an injured party cannot recover damages if they are found to be 50% or more or 51% or more at fault, depending on the state's specific rule. If their degree of fault is less, they can recover damages, with the award being reduced in proportion to their level of fault. Modified comparative negligence is followed by 33 states at the time of this video. South Dakota is the only state that adopts a unique version of the modified comparative negligence system. It differentiates between slight and gross negligence. This means that if an injured party's negligence in an accident is deemed slight and the defendant's negligence is deemed gross, the plaintiff's slight negligence will not bar them from recovering damages. However, if the injured party's negligence is more than slight, it could prevent them from recovering damages. So obviously, liability apportionment is a huge factor in any $1 million case. But to have $1 million case, you also need big damages. Obviously, if you sustain big injuries, you likely have big damages. So if you sustain injuries that have left you in a wheelchair for the rest of your life, the accident that caused your injuries has left you with enormous damages. The 3 most common types of damages in an injury case are medical expenses, lost wages, and pain and suffering damages. Medical expenses for medical treatment can obviously pile up after you have been injured. To have $1 million case, it means you have likely incurred quite a bit of medical treatment, like a surgery or multiple surgeries or extended stays at the hospital. And if you were employed at the time of your accident and had to miss time from work, you can recover lost wages as well. But in many injury cases, the biggest part of the case is pain and suffering damages, and this is true in many million-dollar injury cases. Pain and suffering damages are compensation awarded to you for the physical and emotional distress caused by an accident. These damages cover non-economic impacts like ongoing pain, anxiety, and loss of enjoyment of life. So if you can no longer play your favorite sport, lift heavy objects, or enjoy your favorite hobbies, this gets factored into your pain and suffering damages. But don't forget, you can also claim future damages. So if you need medical expenses in the future, you can recover these future damages, but you will likely need a medical professional to testify or comment on the future medical expenses you will need in order to prove such damages in your case. Likewise, you can also recover damages for any impairment to your ability to earn an income in the future and future pain and suffering damages. But even if you can show liability against another party and significant injuries with huge damages, it does not always mean you have $1 million injury case. That's because the next key factor I discuss is absolutely crucial to have $1 million injury case. To have a big injury case possibly worth over $1 million, you have to usually have a large amount of insurance coverage available to you for your claim, or the at-fault party must at least have deep pockets to pursue. In some cases, the at-fault party might not have any insurance at all. So for instance, if you are in a car accident and the at-fault driver has no insurance and no significant personal assets without a high-paying job, you are likely out of luck of getting a big payday from the at-fault driver. Typically, truck drivers or any type of company vehicle will likely have large amounts of insurance available. Also, if a person is wealthy, they will oftentimes have a large amount of insurance and significant assets to pursue. So if you are in a wreck caused by a commercial vehicle or wealthy individual, those are the types of cases that potentially lead to a big payday. Additionally, large corporations and businesses typically have large amounts of insurance or are self-insured with deep pockets to pursue. So if you have a slip or trip and fall at a grocery, retail store, or some other type of business, for example, those types of cases can also potentially lead to $1 million cases. But don't forget about this last factor. This last factor can also have a huge impact on whether your case is worth at least $1 million. The last key factor is jurisdiction. The jurisdiction that oversees your injury case will also have a huge impact on the potential value of your case. So for example, places like Los Angeles, California, and San Francisco, California, see much larger verdicts in injury cases than anywhere in Kentucky, where I practice law. Now, much of that is due to the fact that the cost of living in those cities in California is much greater than any area of Kentucky. But since verdicts are much larger out there, insurance companies and corporate defendants take that into account when evaluating the value of your case. So, if your accident occurred in a jurisdiction where verdicts commonly surpass $1 million verdicts, your case has a better chance of surpassing $1 million. Now that you know the key factors in determining whether or not you have $1 million case, you may be wondering what mistakes you should try to avoid that can damage your injury claim. And if that sounds like you, then I would suggest you watch this video about to pop up right here, where I cover rookie mistakes that can kill your injury claim. Lastly, if you've been injured in Kentucky, remember to don't wait, call Tate.